Hey everybody, U.S. immigration lawyer Michael Ashoori here, and we have been hearing about increased instances of removal proceedings. Removal proceedings are when somebody has to attend immigration court to be potentially ordered removed from the United States. And as I mentioned, we've been hearing about increased instances of the initiation, the commencement of removal proceedings. So I want to give you some background information. Toward the end of February, earlier this year, USCIS published a policy memo highlighting the various instances where somebody could receive an NTA. An NTA is a notice to appear in immigration court. Now, getting an NTA is very significant. It means that it's the start of removal proceedings where you're required to attend immigration court on a particular day to undergo immigration proceedings to potentially be found to be ordered removed from the US. Now, one of the shocking aspects of this policy memo that was issued by USCIS was one of the grounds that it specified as a reason why somebody could receive an NTA. In that policy memo issued on February 28th, on Roman numeral 6, it says that one of the reasons why somebody could receive an NTA is, it says here, USCIS will issue an NTA where upon issuance of an unfavorable decision on a benefit request, the alien is not lawfully present in the United States. So in an earlier video, I talked about how this is highly significant because sometimes people are here on a valid non-immigrant status and they'll either apply to change their status to a different non-immigrant status, or they'll apply to adjust their status to become a lawful permanent resident. And perhaps a very common occurrence is that the person will file that application to either change status or adjust status, and while their new application is processing, their underlying status will expire. So under the language of this policy memo, if that individual that applied for the change of status or adjustment of status gets that application for the change of status or the adjustment of status denied, and upon the denial, their underlying non-immigrant status has since expired. So now they're in the United States without lawful status. And as you can see here from the language of this USCIS policy memo, again, it says USCIS will issue an NTA where upon issuance of an unfavorable decision on a benefit request, the alien is not lawfully present in the US. So under the example that I just highlighted, somebody could receive a notice to appear in immigration court, an NTA. And that's very significant because, again, with the commencement of removal proceedings, somebody could be ordered removed from the US and could potentially face immigration bars from returning back to the US. So this is very significant. Now, back when that policy memo was published in late February, immigration lawyers were wondering if this was going to result in an increase in removal proceedings. And on June 12th, 2025, USCIS published a news release confirming that since February, USCIS has initiated removal proceedings against over 26,000 people. Take a look at my screen and we're going to read through some of this news update. The title is USCIS initiates removal proceedings against 26,000 aliens since February. And again, this article was published on June 12th, 2025. And it says here, since U.S. Citizenship and Immigration Services published new guidance on issuing notices to appear, NTAs, on February 28th, it has initiated removal proceedings against more than 26,700 aliens with no legal basis to remain in the country. The guidance is in response to President Trump's executive order protecting the American people against invasion. The guidance addresses national security, public safety, and the overall integrity of the United States immigration system by strengthening enforcement of the Immigration and Nationality Act. This update has helped USCIS enforce existing immigration laws by once again issuing NTAs to removable aliens in the United States, said USCIS spokesman Matthew Trageser. Under the leadership of President Trump and Secretary Noem, we have returned to common sense NTA policies and since February 2025 have issued tens of thousands of NTAs to restore integrity and ensure the security of our nation's immigration system. Under the new guidance, USCIS is generally defaulting toward issuing NTAs after the issuance of an unfavorable decision on a benefit request where the alien is removable from the United States. In limited situations, USCIS exercised prosecutorial discretion. The new guidance did not change procedures for cases in which NTA issuance was required by statute or regulation, nor did it change NTA procedures for TPS or deferred action for childhood arrival, DACA cases. So there you have it. In February, USCIS provided a policy alert making clear that they would be issuing NTAs for people in certain circumstances, and it appears that since the issuance of that policy alert until now, that there have been over 26,000 issuances of NTAs. So for those of us that were wondering, was USCIS serious about its February policy alert? It appears that they are very much serious. So this is something that our audience should definitely be informed about. I hope you got some value from this video. As always, thank you so much for tuning in, and I will see you on the next video.